I'm Ben Meiselas from the MeidasTouch network. So there is one E. Jean Carroll case that is going to trial next week on April 25th for defamation and rape. That case is before Judge Lewis Kaplan in the Southern District of New York, the federal courthouse in Manhattan. But there is also another E. Jean Carroll case. E. Jean Carroll filed two separate lawsuits, E. Jean Carroll 1 and what has been referred to as E. Jean Carroll 2. E. Jean Carroll 2 is the case that is going to trial on April 25th. Now, what about E. Jean Carroll 1? Why is there two E. Jean Carroll cases? But the issue with E. Jean Carroll 1, E. Jean Carroll's first lawsuit, that one has not been set for a trial. That trial date has been vacated while it worked its way through the Court of Appeals, and finally, the Second Circuit Court of Appeals made a ruling that is not favorable to Donald Trump, that basically remands or sends the case back to Judge Lewis Kaplan, who's presiding over the E. Jean Carroll 2 case, who previously ruled against Donald Trump on the E. Jean Carroll 1 case, and who has consistently been ruling against Donald Trump in all of Trump's motions in E. Jean Carroll 2. I know it's a little bit complicated, but let me try to unpack all of this information for you. So in 2019, Donald Trump was giving a press conference and also made multiple other statements and other fora to the press that E. Jean Carroll alleged defamed her. Donald Trump made statements that she was lying when she wrote a book accusing Donald Trump of rape, and Donald Trump made a lot of other horrific statements about her, saying that she's not his type, and just other really, really horrific statements. So in 2019, she filed a defamation lawsuit. She was not able to file at that time a lawsuit for sexual assault based on her allegations that Donald Trump raped her in 1995 or 1996 at a Bergdorf Goodman department store in New York, because the statute of limitations had passed. So she files this lawsuit against Donald Trump based on his summer of 2019 statements. She first files it in state court in Manhattan. Donald Trump then removes the case to federal court, and Bill Barr then asserts that the United States should be substituted in. Bill Barr, the former Attorney General, asserts the United States should be substituted in place of Donald Trump, so that the case would now be E. Jean Carroll versus Donald Trump. And this substitution of the United States in place of Donald Trump would be pursuant to what was called the Westfall Act. And the Westfall Act has two parts to determine whether the United States is the appropriate defendant. The first level of inquiry is whether or not the role of the individual being sued, in this case the president, is a government employee. And the second prong of the Westfall Act test is whether or not the statements made or the conduct by that government employee is in the course and scope of that government employee's job title and job duties as a government employee. Now, because the Federal Tort Claims Act doesn't give a plaintiff the right to sue for defamation, if the two prongs of the Westfall Act were satisfied, and Bill Barr was able to substitute in the United States in place of Donald Trump's name being sued in his individual capacity for the defamatory statements he made, the case would be automatically dismissed, and there would be full and absolute immunity for a government employee in the course and scope of their employment who's engaged in defamatory conduct. So a motion to dismiss was filed by Donald Trump, and Judge Lewis Kaplan in E. Jean Carroll 1, that first case, rejected Donald Trump's claim that he was going to substitute in the United States government in place of his name. And Judge Lewis Kaplan found, first, the role of the president is not a government employee within the meaning of the Westfall Act. And in any event, number two, Donald Trump's conduct was not in the course and scope of his employment as a president when he made these defamatory statements about E. Jean Carroll. It's not the type of thing that a president or government employee is supposed to do within their course and scope of employment. So that was the ruling made by Judge Lewis Kaplan. Donald Trump and his lawyers then appealed that ruling to the Second Circuit Court of Appeals, which oversees the Southern District of New York. And the Second Circuit Court of Appeals analyzed the Westfall Act, and under the first prong of the Westfall Act, whether or not Donald Trump was a government employee, the Second Circuit said yes, he was a government employee. The role of president satisfies what it means to be a government employee under the Westfall Act. But second, whether or not the conduct was in the course and scope of Donald Trump's employment as a government employee when he made these defamatory statements, the Second Circuit says we are not going to opine on that as of yet. We want guidance from the Washington, D.C. District Court of Appeals. So that's not a federal court. That's the highest court within the District of Columbia, almost like a state court, but Washington, D.C. is the district. So the Washington, D.C. District Court of Appeals was asked to answer a question certified by the Second Circuit Court of Appeals. And the Second Circuit Court of Appeals asked this Washington, D.C. Court of Appeals whether they were able to opine whether Trump's conduct took place within the course and scope of his employment. But the second question was if Washington, D.C. Court of Appeals can clarify what the law is about what constitutes working within the scope and course of one's employment and which test should be ultimately used. So the Washington, D.C. Court of Appeals heard oral argument, and ultimately they sent their answer back to the Second Circuit, and they basically said they follow what's called a restatement of torts regarding whether or not conduct falls within the course and scope of someone's employment. And they said that is a very fact-intensive inquiry. And so to answer the other question, Second Circuit Court of Appeals, that you're asking us, because it's such a fact-intensive inquiry, we, the Washington, D.C. Court of Appeals, we don't feel that we are the proper authority to apply the law, this what's called a restatement of torts, regarding what constitutes course and scope of employment as it relates to Donald Trump. So we'll let you know what we think the test was. Here's the test. We follow what's called the restatement of torts, and that is a fact-intensive inquiry. But Second Circuit Court of Appeals, you're going to have to make the determination about whether or not Donald Trump's conduct itself is within the course and scope of its employment. So that's how the Washington, D.C. Court of Appeals answered it. They then sent that question back to the Second Circuit Court of Appeals. Now, while all of this was going on, what else has occurred?
And now let's take a quick break to talk about our next partner, Fume. Cold turkey, it may be great on sandwiches, but there's a better way to break your bad habits. We're not talking about some weird mind voodoo from your wacky neighbor or some sketchy message board. We're talking about our sponsor, Fume, and they look at the problem in a different way. Now, not everything in a bad habit is wrong. So instead of drastic, uncomfortable change, why not just remove the bad from your habit? Fume is an innovative, award-nominated device that does just that. Instead of electronics, Fume is completely natural. Instead of vapor, Fume uses flavored air. And instead of harmful chemicals, Fume uses all natural, delicious flavors. You get it. Instead of bad, Fume is good. It's a habit you're free to enjoy and makes replacing your bad habit easy. Your Fume comes with an adjustable airflow dial and is designed with movable parts and magnets for fidgeting, giving your fingers a lot to do, which is helpful for de-stressing and anxiety while breaking your habit. The first time I used Fume, I was shocked at how flavorful and fresh it tasted. Now, it's easy to hold and perfectly balanced and quite honestly, extremely fun to fidget with. The real wood material and sleek design definitely classes it up, and I feel pretty darn cool holding it. Stopping is something we all put off because it's hard, but switching to Fume is easy, enjoyable, and even fun. Fume has served over 100,000 customers and has thousands of success stories, and there's no reason that can't be you. Join Fume in accelerating humanity's breakup from destructive habits by picking up the Journey Pack today. Head to tryfume.com and use code MIDAS to save 10% off when you get the Journey Pack today. That's tryfum.com and use code MIDAS to save an additional 10% off your order today.
Well, in October of 2022, Donald Trump went on his social media platform and essentially said the same defamatory things that he said back in 2019 when he was in office as president, but he now said it when he was not in office. So he cannot claim any protections under the Westfall Act or under immunity within the course and scope of his employment, because now he said all of those same defamatory things on his social media platform, and he no longer holds the office where he could try to invoke this immunity that was subject to all of these appeals. So this whole legal process taking place, Trump just kind of ruined it by posting it on his social media platform in the first place. What else happened in New York? Well, the New York governor signed into law what's called an Adult Survivors Act, which had a 1-year look-back period for victims of sexual assault whose statute of limitations expired. So in New York, if you were a victim of a sexual assault under a new law, if your statute of limitations expired, as E. Jean Carroll's did, because she normally would have had 2 years from 1995 or 96 within which to bring her civil lawsuit, so it would have been 97 or 98. But under the new law, you have 1 year to bring your claim regardless of when your claim expired under the statute of limitations if you're a victim of sexual assault. So E. Jean Carroll, as soon as that law went into effect, she filed the case that's now called E. Jean Carroll 2. That's the case that's going to trial on April 25th. And that has a claim of rape in a civil context, but it's still an accusation that Donald Trump raped her back in 1995 and 96. She's allowed to bring that now because she's got this 1-year period under the New York Adult Survivors Act, as well as for the defamation that Donald Trump made on his social media platform in October of 2022. So that's the case that's going to trial April 25th. Well, on Friday, the Second Circuit Court of Appeals, which now received the answer back from the D.C. Court of Appeals, the District of Columbia Court of Appeals, regarding course and scope of employment, the Second Circuit said, okay, the D.C. Court of Appeals, they answered our question, at least in terms of what they believe the test to be, to determine if the conduct's within the course and scope of employment, but they would not answer the question about whether Donald Trump's conduct was within the course and scope of his employment when he said these alleged defamatory things about E. Jean Carroll. The Second Circuit said, we too, it's not our job as the Court of Appeals in the federal court to make that fact-intensive inquiry, so we are going to send that question back to the district court judge. We're going to send that back to the federal judge. Which federal judge is it? Judge Lewis Kaplan. So ultimately, it's going to be Judge Lewis Kaplan's determination to make. Now, Judge Lewis Kaplan will decide about whether or not there is a factual dispute such that Donald Trump's request to dismiss E. Jean Carroll 1, whether that should be denied. And ultimately, what Judge Lewis Kaplan will find, although the ruling hasn't been made yet, Judge Lewis Kaplan already didn't think the Westfall Act applies to begin with. He didn't think that the conduct was within the course and scope of Donald Trump's employment. So clearly, Judge Lewis Kaplan's going to say that this is a fact-intensive inquiry, and that this cannot be decided as a matter of law at a motion to dismiss phase, and ultimately should be decided by a jury. Okay, so now with E. Jean Carroll 1 and E. Jean Carroll 2, you know, the distinctions, but E. Jean Carroll 2 is going to trial. So what's going to happen to E. Jean Carroll 1 now? Well, I think ultimately what happens is E. Jean Carroll 2 goes to trial, and necessarily the outcome of that case is going to become the same outcome of what's going to happen to E. Jean Carroll 1. Because if the court, or rather if the jury, makes a finding that one, E. Jean Carroll was raped, and two, that Donald Trump's statements were defamatory, that's going to basically answer the questions regarding E. Jean Carroll 1, and E. Jean Carroll will basically get to bring another case before the jury, E. Jean Carroll 1, with a finding already being made by a jury that Donald Trump defamed her. Because again, the defamatory statements in E. Jean Carroll 2 on Trump's social media platform, same statements he made back in 2019 when he said the things at a press conference. So that's why the judge, I think very smartly, phased this with, okay, let's do E. Jean Carroll 2 then, while E. Jean Carroll 1 is in the Court of Appeals. Now, there is perhaps a small possibility that E. Jean Carroll 1 gets merged with E. Jean Carroll 2, although on the eve of trial, I'm not sure how easy that would be to do it. But in any event, the outcome ultimately will be the same. So if E. Jean Carroll 2, what's going to trial, she wins, she's going to win in E. Jean Carroll 1. It's just going to take time for that one to now work its way through through the court system. So that's the update. But again, a big important ruling by the Second Circuit, again, a ruling against Donald Trump, where Trump wanted this whole thing, E. Jean Carroll 1, dismissed. That's not going to happen. Now, the impact of the Second Circuit ruling would have been more significant had Donald Trump not defamed E. Jean Carroll again the second time, and the Adult Survivors Act statute not passing. But nonetheless, it's still an important, I think an important ruling, and not a favorable ruling in any sense for Donald Trump. A bad ruling, another bad ruling for Donald Trump, but the right ruling ultimately, just more losing by Donald Trump. I'm Ben Meiselas from the MeidasTouch Network. Thanks for watching. Hey, hit subscribe. We're on our way to 1.5 million subscribers thanks to your incredible support. It's free to subscribe to our YouTube channel, so please hit subscribe. Also, no matter where you get your audio podcasts, so if you use Spotify or Apple or Google Play, wherever you get your podcasts from, if you can subscribe to the MeidasTouch podcast as well, that's very helpful. And so please make sure you subscribe there, and it's free. And also, if you want to become a member of the MeidasTouch Patreon community, that's how one of the ways we fund this. Go to patreon.com/MeidasTouch, patreon.com/MeidasTouch. Check it out there. And it does go a long way to help, but no worries if you can't. All right, hit subscribe on our YouTube channel. Thank you so much for watching.
Lock him up! Indictment season is upon us. Celebrate with the new Indictment Season t-shirt and v-neck exclusively at store.MeidasTouch.com.